Good day, everyone. I'm going to be reading on Unit 3, Civil Procedure CIV 3701. Civil Procedure in Context. You decide to visit the division of the High Court of your area to better understand the civil procedural system. What you learn could have been equally relevant to the magistrate's courts, but you happen to be in the High Court. As you enter the building, you see a sign that reads Registrar. You enter the registrar's office. You notice that there are no judicial officers, only clerks. The latter sit behind a counter and accept documents referred to by all as processes and pleadings lodged by the representatives of various legal firms. You notice that the clerks also issue summonses and notices of motion on behalf of attorneys. You will then sit in on a civil trial. The atmosphere is very formal, and you notice that the judge does not interfere with the trial except to ask questions occasionally. The proceedings in court are conducted by counsel on behalf of the litigants. Counsel on both sides are very assertive and are sometimes even aggressive towards each other or the witnesses for the opposing side, while testing the oral evidence presented by the opposing side. Your impression is that of a legal contest between counsel on behalf of their clients. At the end of the trial, the judge considers the presentations in court and then hands down judgment. You notice that one of the parties appears to be satisfied with the outcome, but that the other seems less so. As you ponder the situation, you wonder whether there is a different way of resolving disputes so that one party is not left the loser and feeling unhappy about it. There is the overview. 3.1 Adversarial System of Civil Procedure. 3.2 The Role of the Court. 3.3 The Legal Profession. 3.4 Critical Appraisal. 3.4.1 Litigants. 3.4.2 Competitive Representation. 3.4.3 Public Proceedings. 3.4.4 Delay. 3.4.5 Course of Litigation. 3.4.6 Adjudicatory Process. 3.4.7 Reformation Civil Procedure. 3.5 Alternative Dispute Resolution ADR. 3.5.1 ADR Explained. 3.5.2 Formal Litigations. Response to ADR, Court Annexed Mediation. 3.6 Dispute Resolution Mechanisms in African Customary Law. 3.6.1 Introductory Remarks. 3.6.2 Processes Employed by African Customary Law. 3.6.3 ADR Elsewhere in Africa. 3.7 The impact of the Constitution 1996 on selected areas of the South African Law of Civil Procedure. 3.7.1 General. 3.7.2 Selected areas evincing constitutional influence. 3.8 A few remarks on the conduct of the practitioners. Moving on to learning outcomes. After studying the study unit, you should be able to discuss the adversarial system of procedure, differentiate between the Anglo-American and continental systems of civil procedure, identify the underlying principles of bilaterality, party prosecution, and party presentation, explain the role of the court, critically appraise the adversarial system as well as the methods of civil procedural reform, discuss the common characteristics of ADR processes, evaluate litigation and ADR with relation to their respective strengths and weaknesses, identify and explain the dispute resolution mechanisms in African customary law. And then we have compulsory reading, Pett et al. Civil Procedure, 4th edition, 2023, page 575. 3.1. The adversarial system of civil procedure. Because it is part of the system of Anglo-American civil procedure, a dominant characteristic of South African civil procedure is that it adheres to the adversarial system of litigation. All South African courts of law, except the small claims courts, apply adversarial principles and procedures. What is meant by an adversarial system of litigation? Because of its complexity, a simple definition is not possible. However, a basic understanding can be gained by briefly comparing the application of adversarial litigation with continental procedure. Continental civil procedure is characterized as being inquisitorial, or assuming the nature of an inquiry which is controlled and conducted by a judicial officer. The inquisitorial system is common in many countries with a civil law system in continental Europe, such as France, Germany, and Switzerland. Characteristics of the continental system. In the inquisitorial, the judicial officers participate directly in the process of litigation from the commencement of the proceedings until the conclusion of the hearing. Along with the parties, judicial officers are actively involved in the conduct of the proceedings and in determining the facts of the case. Other characteristics of the continental system are as follows. Pleadings are in the form of notices to the parties and includes evidence in certain instances. Judicial officers are involved in the gathering of evidence. The trial is in the form of a hearing in which a judicial official may participate actively by asking questions and sometimes by leading evidence. In summary, in the continental system, a judicial officer is the trier of both fact and law, unlike the Anglo-American system, which relies on case law and precedent. The continental system places more reliance on statutory code provisions than on the precedents arising out of decided cases. In the continental system, the creation of law through case precedents is sometimes viewed, at least to some degree, as an improper usurpation of power reserved solely for the legislature. Since the precedent system does not apply, a court decision, what we call a judgment, is only of persuasive value and is not binding as law in regard to other courts. In contrast, Anglo-American civil procedure is adversarial in nature. It is a system generally adopted in common law countries such as the United States of America, the United Kingdom, Canada, Australia, and South Africa. Characteristics of the Anglo-American system. The system regards litigation as a private matter and relies on the legal representatives of parties to prosecute their respective claims or defenses. Therefore, the Anglo-American civil procedure system is a contest between the parties and or their representatives. The legal representatives are also responsible for gathering and presenting their evidence to a judicial official at trial. The trial in the Anglo-American civil procedure is marked by its orality. It is predominantly oral in nature. This means that viva voce evidence, that is oral evidence given by witnesses in person, is led by the counsel for both litigants by means of examination, cross-examination, and re-examination. The orality of the proceedings also applies to the judicial official. who gives oral judgment even when written. Always read aloud immediately, unless judgment is reserved. What is evidence is that the proceedings are marked by distinct pre-trial and trial stages. Two distinctive activities occur during the pre-trial stage. Firstly, the pre-trial stage opens with the exchange of pleadings between the litigants to define issues in dispute that must be presented and proved at the trial. Secondly, after the pleadings have closed, a trial date is requested, and during this waiting period, the litigants prepare their respective cases for trial. Okay, VMI. During both the pre-trial and trial stages, the judicial official plays a passive role. It means that the judicial official does not interfere in the proceedings except upon the request or motion of one of the litigants. Like an umpire of a game, the judicial officer is more interested in ensuring the fair play of due process or of fundamental justice. It is important not to generalize about the inquisitorial system and the adversarial system. Both systems vary from country to country. There may be subtle or even substantial differences among many countries that have adopted either an inquisitorial or an adversarial system of civil procedure. This brief description expresses three fundamental principles that underlie our system of civil procedure. These principles are bilaterality, that is, in the present context, bilateral means between two parties. The principle of bilaterality assumes that both litigants or all parties, if there are more than two litigants, will have a fair and balanced opportunity to present either their respective claims or defenses. Inherent in this principle is the belief that the truth will emerge even or if each party presents their own biased view of the issues in dispute. Party prosecution. Party prosecution refers to the competence of a litigant either to commence or begin or defend proceedings and to move or prosecute the case forward through all its procedural stages. This principle reinforces the notion that litigation is a private matter that is conducted by both litigants without any interference from the court, except where its intervention is requested by one of the litigants. In practical terms, this means that a person whose substantive rights have been infringed on or alienated has a choice either to commence civil proceedings or simply do nothing about the matter. Likewise, if a person commences proceedings as a plaintiff or applicant, then the person against whom proceedings have been commenced, that is the defendant or respondent, may also make certain choices. Party presentation. Party presentation refers to the competence of a litigant or to investigate his or her own cause or defense, to formulate the issues in dispute as well as to present the material facts concerned, and to prove these facts and raise legal argument in support of these facts before a court. The principle of party presentation confirms that a litigant has control of the content of his or her case, of her cause or defense, as the case may be. Litigants are competent to determine the scope of the controversy, that is the issue in dispute, and to define the boundaries or scope of the dispute without the interference of the court. The principle of party presentation supports the idea that the litigants should be masters of their rights. For instance, a defendant may consent to judgment, defend the action, or simply ignore the summons. Another option that is frequently used is that both litigants may negotiate what is called an out-of-court settlement. Although discussed separately, it should be remembered that in a practical setting, These principles are interdependent and interrelated. 3.2. The role of the court. As in other Anglo-American jurisdictions, in South Africa, the role of the judicial officer is passive. The notable exception is that of a commissioner of small claims court. Often the passive role of the judicial official is likened to that of an umpire who ensures compliance with the rules of the game, but does not participate in the game itself. In its absolute sense, the role of the judicial official is passive in that he or she is restricted to the evidence that the litigants have chosen to present during a trial or a hearing on motion. Usually, judicial official may not introduce new evidence or raise additional matters of the law. In brief, the judicial official is not responsible for ensuring that the case presented by each litigant is complete. The judicial official reaches a decision on the case purely on the basis of the evidence and arguments in law put forward by each litigant. Unlike the judge in a continental system of civil procedure, a judicial officer is burdened with the official duty of judicial investigation. However, there is a growing tendency to encourage judicial activism. Limited judicial intervention is permitted in systems where fast-track litigation has been introduced, that is in Australia, for example, or in respect of schemes relating to judicial management of complex litigation, e.g. in the USA. 3.2. The legal profession. In principle, every litigant is entitled to appear personally before a court to plead a cause or to raise a defense. However, because the conduct of the litigation is so specialized, litigants normally instruct attorneys and advocates to conduct litigation on their behalf. The only exception is in the small claims court, where legal representation is prohibited. Members of the legal profession therefore act as agents of their clients and represent their clients' rights in court. However, these functions occur within the context of adversarial procedure. Consequently, legal representatives are duty-bound to promote and protect their litigants' clients' interests. It is in this sense that it is said that legal representatives must take a partisan stance on behalf of their clients. 3.4. Critical appraisal. In the context of Anglo-American procedure, the purpose of adversarial system is to elicit or arrive at the truth by means of presenting opposing views in respect of the same case. However, the system is based on certain assumptions that do not always reflect reality. Although in theory both litigants have an equal opportunity to present their cases, they do not necessarily always have the same financial resources to conduct litigation, nor are the skills of counsel always equally matched. Moreover, rivalry caused by a competitive approach to litigation does not necessarily ensure that the litigants acting through counsel will fully disclose the facts, especially those that might discredit their own cases. Furthermore, because the system operates in a manner that promotes a partisan approach to litigation, litigants are prone to using procedure for tactical purposes to further their own individual interest and demoralize opponents. In psychological terms, an adversarial approach does not reconcile the litigants but rather tends to accentuate their differences and consequently heightens the conflict. 3.4.2 Competitive representation. Owing to the technical nature of procedure and competitiveness of proceedings, the system itself forces the lawyer to reshape the litigant's human problem into legal and procedural categories that meet the demands of adversarial system, but very often fail to represent the litigant's actual human needs. An example is the trauma involved in a divorce, which is just heightened by the adversarial nature of the related proceedings. 3.4.3 Public proceedings. Courts are public institutions that play a vital role in fulfilling the governmental function of maintaining order in society. Because courts have a public function, proceedings are conducted in open courts. Consequently, private grievances, especially those of a domestic nature, are made public. The same is true for commercial matters that may be highly confidential and best kept secret in a competitive market. 3.4.4 Delay. Justice delayed is justice denied. This statement expresses the frustration of many litigants whose rights remain undecided while they wait for their day in court. Consequently, rather frequently, delays are caused by the technical nature of procedure, the formality of proceedings, the competitive tactics, and strategies that are the inevitable result of adversarial litigation. Procedural delays have serious personal and financial consequences for litigants because they are unable to lead normal lives or to continue trading freely, for example, while litigation is in process. 3.4.5 Cost of litigation. In principle, access to courts is free. Court administration and court time are provided free of charge by the state. The problem lies in the costs incurred by lawyers who conduct litigation on behalf of their clients, the litigants. Owing to the complexity of legal issues and the intricacy of procedure, representation by a lawyer is normally essential. In return for acting as agents for their clients, lawyers charge a fee that is often beyond the means of the average citizen, not to mention poor persons. The result is that recourse to the courts is restricted mainly to those who can afford it or who qualify for legal aid. 3.4.6 Adjudicatory process. The judicial officer decides or adjudicates the matter impersonally, playing the role of a passive umpire. Attention is focused on the weight of the evidence and the merits of the legal arguments presented by each party. Because adjudication occurs in an adversarial setting, judgment is granted in favor for only one of the litigants. Unless absolution from the instance is granted, there is always a winner and a loser. The system does not permit a method of decision-making that reconciles the conflicting interests of litigants. This has the effect of increasing the tension between litigants, especially where they are bound to each other in a continuing or long-term relationship, as in the case of neighborhood, testamentary, or domestic disputes, or in the business environment. 3.4.7 Reforming civil procedure. The reform of civil procedure is a highly complex matter that obviously cannot be dealt with in any depth here. What follows is only a very brief outline of the various methods for reforming civil procedure, which will hopefully sharpen with critical perspective. The first way in which to reform civil procedure is by means of the continual revision of the rules of court. Another method is to increase the jurisdictional limits of the lower courts to give more people access to court, but at the lower cost than will be the case of increasing access to a high court. Another method of reform is to exclude, in part or in whole, Specific types of disputes from the court system. A good example of an act that does this is the Labor Relations Act 66 of 1995, which both prescribes dispute resolution procedures and establishes courts that deal with labor matters only. Reform is sometimes effected by means of establishing alternative fora. Fora is the plural of the Latin word forum, which in this context means a court. Small claims courts, as courts of minor jurisdiction, have been established as an alternative to litigating in the magistrates' courts. Another method encourages the resolution of disputes outside the court system through the use of informal dispute resolution processes. This is known as alternative dispute resolution. In certain Anglo-American jurisdictions, informal processes have sometimes been introduced within the court system. This means that informal processes have been incorporated into the rules of the court to encourage the settlement of disputes by means of arbitration or mediation, thus saving costs, avoiding delays, or making allowances for the personal interest of the litigants. 3.5 Alternative Dispute Resolution. Study Pitt et al. That is the prescribed book, page 575. 5.5.1 Alternative Dispute Resolution Explained. ADR is an abbreviation that stands for Alternative Dispute Resolution. It is possible to describe ADR as a system of dispute resolution that uses a variety of informal processes as a means of resolving disputes both in and outside the court system. Negotiation, mediation, and arbitration are traditional processes. Within the context of ADR, these processes are also known as primary processes. Although there are differences between many of these processes, they all fall within the system of ADR because they share several common characteristics. ADR processes are informal. In comparison with the processes of litigation, ADR processes are neither bound by strict rules or procedure nor constrained by technicalities. Flexible. ADR processes can be adapted to suit the needs of particular kinds of disputes in different contexts or situations, such as the case of labor, commercial, industrial, family, and divorce, and environmental issues, or in the case of international relations and out-of-court settlements. Voluntary. The disputants are not compelled to enter into the process except when an ADR process is used within the court system. Consensual. They function on the basis that the outcome or result or decision of a process is reached through the consent of both disputants. Interest-based. The interests of disputants rather than their rights in law are allowed to predominate. Relational. ADR processes emphasize the relationship between the disputants and are therefore highly suited to dispute between persons who are in a continuing or long-term relationship, e.g., directors of a company. Future-oriented. Apart from the case of full arbitration, ADR processes do not focus on blame for past events, but rather concentrate on establishing or re-establishing the future relationship between the disputants. It is evident that the characteristics common to all ADR processes are diametrically opposed to those of the process of litigation. This is, in fact, the main reason for including a study unit on ADR in this module. ADR processes challenge the process of litigation. Indeed, as the word alternative suggests, ADR processes may sometimes offer an alternative to the process of litigation. Litigation is the mainstream model of dispute resolution against which ADR processes are posed as an alternative. 3.5.2 Formal litigation's response to ADR, court-annexed mediation. Mediation is a process in which parties who experience conflict require the assistance of an impartial third party mediator to help them reach agreement. The mediator acts only as a facilitator and does not decide the outcome of the conflict. This remains in the hands of the parties. Because the process is voluntary and the parties remain in control of the process, mediation is generally viewed as empowering to both parties. Supporters of mediation claim a high success rate for mediated matters. These and other claimed benefits of mediation, together with a desire to give effect to Section 34 of the Constitution, access to courts, and to increase access to justice, a form of mediation, court-annexed mediation, was introduced as an alternative dispute resolution mechanism within the court system, the civil court system, and more specifically the magistrates' courts. Consequently, Chapter 2 was inserted into the Magistrate Courts rules in 2014 and was recently repealed and replaced by a new Chapter 2 GNR 3371 of 5 March 2023. The stated purpose of these rules is to provide the parties to litigation with the opportunity to submit their dispute to mediation, either of their own accord, thus by agreement, or upon inquiry by the court. R70. The rules provide that in any new action or application, the plaintiff or applicant must, together with the summons or notice of motion, serve a notice on the opposing party indicating whether such plaintiff or applicant agrees to or opposes referral to mediation. Likewise, a defendant or respondent shall do the same when delivering a notice of intention to defend or to oppose. R72. The mediation process is regulated R73 to 77, and unless the parties agree otherwise, mediator fees are borne equally by the participating parties. R78. It is important to note that the court, when considering an order of costs in an action or application, may have regard to the notices referred to in Rule 72 or to any offer or tender made during mediation. R 79. The High Court followed suit, and Uniform Rule 41A has introduced mediation. In terms of this rule, the plaintiff or applicant, depending whether the proceeding to be commenced is a summons or an application, is obliged to serve on each defendant or applicant a notice indicating whether he or she agrees to or opposes referral to the dispute of mediation. This notice must be served simultaneously with the summons or notice of motion, as the case may be. Rule 41A.2.a. A defendant or respondent has a corresponding duty to indicate by notice his or her agreement or opposition to such referral when delivering a notice of intention to defend or notice of intention to oppose, as the case may be, or at any time thereafter, but not later than the delivery of a plea on the merits of answering affidavit. Rule 41A.2.b. However, regardless of the provisions of Rule 41A.2, parties may at any time before trial agree to refer the dispute to mediation, but once the trial or application commences, leave of the court is required. Rule 41A.3. Furthermore, the court or a case management judge, see Rule 37A, may at any time before judgment direct the parties to consider referral of the dispute to mediation. That is Rule 41A3. Right, where a matter is referred to mediation, the parties must comply with certain procedural requirements whereupon all normal litigation proceedings, including time limits prescribed by the rules, are suspended until the conclusion of the mediation. Rule 412A.4, the mediation must be concluded within 30 days. Rule 41A.4.d, but if the suspension of time limits is being abused, the suspension may be uplifted upon application. That is Rule 41A.5b. It is specifically provided that all communications and disclosure made during mediation proceedings are confidential and inadmissible in evidence. Likewise, no offer or tender made without prejudice may be disclosed to the court prior to the judgment. Rule 41A.6, 41A.8d. When the court trial may have regard whereto for purposes of a court order. Rule 41A.9. When considering a court order, the court may also have regard to the notices by the parties indicating whether they agreed to or opposed referral of the matter to mediation. No doubt, this is a coercive provision designed to favor the use of mediation. Upon conclusion of the mediation proceedings, the parties must inform the registrar by notice of the fact, issue a joint minute indicating whether mediation was successful or not, as well as the issues agreed upon and that do not require hearing by the court. Rule 41A.7 to 8. Unless the parties agree otherwise, the fees of the mediator must be borne equally by the parties. Rule 41A.9. 3.6. Dispute resolution mechanisms in African customary law. 3.6.1 Introductory remarks. Dispute resolution mechanisms in African customary law have the following characteristics. They follow the oral tradition, although they are influenced by Western traditions. The participants comprise a collective group of people who are free to participate in the discussions. The processes are victim-oriented. The processes are informal and flexible. The outcome is restorative justice or the restoration of social harmony or peace. The use of state authorities is the exception rather than the norm. Most disputes in African customary law are settled in a satisfactory manner without recourse to the courts. This is achieved by means of negotiations within and between groups of relatives. If a particular problem cannot be resolved in this manner, then two or more options are available to the disputants. The first option is to use the process of mediation before a formal appeal is made to the courts. Mediation involves a process whereby a party that is not involved in the dispute, that is, an impartial party, tries to help the people involved in the dispute to come to an agreement or find a solution to the problem. In the event of mediation failing, the next option is to follow the court procedure. 3.6.2 Processes employed in African customary law. Two processes are usually used in African customary law to resolve disputes, namely negotiation and mediation. Disputes can be resolved within family groups or between non-related family groups. First, we examine the settlement of disputes within family groups. 3.6.2.1 The settlement of disputes within family groups. Family disputes are settled at the common ancestral home by the head of the family group, who is also responsible for the conduct of his or her family members, the following procedure is employed. The correct procedure is negotiation with a view of reconciliation or restoration of social harmony or peace. The head or the senior figure is assisted by adult members of the family. Family matters are generally regarded as private. If the matter cannot be settled within the family cycle, senior relatives or neighbors are invited to help resolve the matter. The objective is to look at ways to resolve the disputing parties and restore normal family relations. If a solution to the problem is found, then the head pronounces the outcome, which is accepted by everyone. This procedure ends with a ritual that involves everyone partaking of the same meal or shaking hands or hugging one another to symbolize the end of the dispute. If the proposed solution is not accepted by the disputing parties, then the headman, head of the customary court in a particular district, serves as a mediator and is tasked with making a formal judicial decision. 3.6.2.2 The settlement of disputes between non-related family groups. The procedure is as follows. The people involved in the dispute first try to settle the dispute among themselves by way of negotiation. All parties participate in the discussions. If no consensus is reached, the headman or village head is invited to assist. He or she acts as a mediator. A ritual in the form of a reconciliatory meal is held if the parties come to an agreement at any stage during the process of negotiation or mediation. This demonstrates the restoration of normal relations and harmony between the parties and the broader community. 3.6.2.3 Concluding remarks. Today, people are not strictly arranged along family lines like they were in the past. Therefore, the practice in rural and urban areas nowadays is to seek the advice of neighbors rather than expect extended family groups. Disputes are also reported to the police, church groups, street committees, and local civic associations. Resolution takes place through negotiation and mediation. Importantly, the contentious Traditional Courts Bill, which is currently still being debated, will affect customary law, the role of the traditional leaders, and the rights of the rural people. 3.6.3 ADR elsewhere in Africa. As in South Africa, ADR in the rest of Africa is not new, as leaders, e.g. elders and chiefs, have for centuries resolved conflicts within the communities through customary dispute resolution mechanisms such as reconciliation, dialogue, and community justice. These practices are now being institutionalized in many African legal systems to complement formal courts and their practices, e.g. in Botswana, Ghana, and Nigeria, to name a few. Because of Africa's diverse cultures, it is generally viewed that ADR mechanisms are more attuned to the cultures as they encourage cooperation and collaboration between disputing parties and allow restoration of relationships. A case in point is Rwanda's post-genocide experience, where its traditional Gasasa courts and not their formal courts handled approximately 1.2 million genocide-related cases between 2002 and 2022 and enabled survivors and perpetrators to enter into dialogue to reach reconciliation and healing. Certainly worth noting. 3.7 The impact of the Constitution 1996 on selected areas of the South African law of civil procedure. The Constitution has a significant influence on civil procedure. The purpose of this discussion is not to deal with the topic in a comprehensive manner, but to inform you in broad terms that civil litigation can no longer be conducted without considering the values embodied in Section 36 of the Constitution. Section 8 provides that Chapter 2, that is the Bill of Rights, applied to all law, and therefore this chapter also applies to the law of civil procedure. Several of the rights enshrined in Chapter 2 directly relate to the law of civil procedure, the most important of our purposes being equality before the law, that is Section 9, the right to freedom and security, Section 12, property, Section 25, and the right to have access to adequate housing, Section 26, and access to courts, Section 34. 3.7.2 Selected areas evincing constitutional influence. Eviction. An owner's common law right to obtain an eviction order is seriously limited by the Constitution and certain land reform legislation. The latter is complex, and the various acts have divergent procedural requirements for obtaining eviction orders in different courts. For the purposes of this module, you'll need only to cognizance of these acts in order to be prepared. In practice, to establish their applicability in a particular instance, the legislation includes the following: Restitution of Land Rights Act 22 of 1994. This act protects the lawful and unlawful occupiers of urban and rural land who have instituted land restitution claims. The Land Reform, that is Labor Tenants Act 3 of 1996, LTA in brackets. This act protects persons living on agricultural land who, instead of wages, have obtained the right to use land for farming purposes. Interim Protection of Informal Land Rights Act 31 of 1996, the IPILRA. This act protects de facto holders of informal land rights in respect of rural and urban land pending the final determination of the status of such rights. The land concerned is mainly found in the former so-called independent homelands. Extension of Security of Tenure 62 of 1997 of 1997 ESTA. This act protects persons living on agricultural land who, instead of wages, have obtained the right to use land for farming purposes. Interim Protection of Informal Land Rights Act 31 of 1996, IPILRA. This act protects de facto holders of informal land rights in respect of rural and urban land pending the final determination of status of such rights. The land concerned is mainly found in the former so-called independent homelands. Extension of Security of Tenure Act 62 of 1997 ESTA. This act protects former lawful occupiers of agricultural land. Prevention of Illegal Eviction from and Unlawful Occupation of Land Act 19 of 1998, the so-called PI Act. This act finds application when the eviction of a person from his or her urban home is sought and applies in respect of land throughout the Republic. If ESTA, IPILRA, or LTA do not apply to a particular case, the occupier falls within the definition of an unlawful occupier as defined in Section 1 of the Act. Then this Act applies. Building and structures that do not fulfill the function of the dwelling or shelter or humans, e.g. commercial property, fall outside this Act. If the land has been occupied for less than 6 months, the court may grant an eviction order if it considers it just as equitable to do so after considering all relevant circumstances, which include the rights and needs of the elderly, children, disabled persons, and households headed by women. If the land has been occupied for longer than 6 months, the court must, in addition, consider if land is available for the relocation of the unlawful occupier. The Act suspends the exercise of landowners' proprietary rights until this determination has been made, and if the procedural requirements of the Act have been met, a landowner may approach the court for an order. Ndlovu versus Ngobo, Becker versus Bosch, Becker and Bosch versus Jiga, the Act clearly confirms certain values such as dignity, equality, and freedom, and requires courts to, where necessary, create innovative remedies to protect and enforce the constitutional rights of the owner and the occupier. Reference Transnet Limited versus Nyauza 2006. Arrest 3.7.2.2. The right to freedom and security, Section 12, led to the Supreme Court of Appeal decision in Bid versus Industrial Holdings, in which it was held that the arrest of a person to confirm or found jurisdiction was unconstitutional. In Malachi versus Cape Dancing Academy, the court confirmed an earlier finding that the section of the Magistrates Court Act 1944 codifying the common law and which authorized arrest quantum suspectus de faga was unconstitutional. Uniform Rule 9 regulating arrest has been repealed and arrest tanquam suspectus de faga no longer exists. 3.7.2.3 Execution. The Constitutional Court held that Jafta versus Schumann that a writ of execution that would deprive a person of adequate housing would be in conflict with such person's rights in terms of Section 26 and would consequently need to be justified in terms of Section 36 subsection 1. Mohoro J. explained the position thus: the interests of creditors must not be overlooked. There must be circumstances when, notwithstanding the relatively small amount of money owed, the creditor's advantage in execution outweighs the harm caused by the debtor. In such circumstances, it may be justifiable to execute. It is in the sense that consideration of the legitimacy of a sale in execution must be seen as a balancing process. For this reason, the court held that execution must be subject to judicial oversight. In Kundwana versus Teko, the Constitutional Court consequently held that in an instance when it was requested that immovable property be declared specially executable after default judgment, the registrar may not grant such an order, and that execution may only follow upon judgment in a court of law. The court further declared the practice under the rules of law of court for allowing a registrar to grant orders declaring immovable property that constitutes a person's home executable constitutionally invalid. Paragraph 55 and 65. Read amended Uniform Rule Section 45 and 46, which give effect to these judgments. Judicial oversight will ensure that the impact that the execution may have on indigent debtors who are at risk of losing their homes be considered, as well as any alternative course of action. It is submitted that it is amended practice ensures compatibility with Section 26 of the Constitution. Of interest is also First Rand Bank Limited, in which the court considered the meaning of the primary residence and home of a person as used in Uniform Rule 46 in Kundwana. The court held that execution against a holiday home or a second home that is not usually occupied by the debtor does not trigger the rule requiring judicial oversight. Likewise, the term judgment debtor was held to refer to an individual who owns a private residence and not to immovable property owned by a company, close corporation, or trust, even if the immovable property is the shareholders, members, or beneficiaries' only residence. Paragraph 31 to 32. Note that the summons initiating an action in which relief is claimed that embraces an order declaring immovable property executable must contain a clause which draws the attention of the debtor to Section 26, subsection 1 of the Constitution. and which informs the debtor about the need to present information to court supporting his or her claim that an order of execution will infringe his or her Section 26 right of access to adequate housing. 3.8 A few remarks on the conduct of practitioners. The conduct of legal practitioners, attorneys, or advocates in practice is subject to a professional code of conduct. The main sources of this code of conduct are the Legal Practice Act 28 of 2014, the rules and rulings of the South African Legal Practice Council, court decisions, the common law textbooks, and the influence of international courts. The purpose of this professional code of conduct is to provide the norms in terms of which it can be established whether prospective and current practitioners are fit and proper persons to practice law. Bear in mind that a practitioner is admitted to practice by the High Court, and therefore a practitioner is termed in office an officer of the court. Because a practitioner is part of the legal system, he or she is compelled to uphold the law at all times and to promote the general administration of justice. This includes a practitioner's duty to respect the processes of court and not to hamper his or her opponents in conducting their cases. The professional conduct of practitioners crops up in various relationships, such as in the relationship with their clients, other practitioners, the courts, the state, the community, and the particular professional body, law society, or bar council. In all these relationships, it is expected that practitioners will conduct themselves with integrity, objectivity, dignity, and good judgment, demonstrating sufficient knowledge and skill, respect of the law, commitment, equity, and fairness. Serious breaches of the code of conduct can lead to the removal from the role of attorneys or advocates as appropriate. The duty of practitioners is well expressed in the following principles laid down in the General Principles of Ethics of the International Bar Association. 1. Lawyers shall at all times maintain the highest standards of honesty and integrity towards all those with whom they come into contact. 2. Lawyers shall treat the interests of their clients as paramount, subject always to their duties to the court and the interest of justice, to observe the law and to maintain ethical standards. 10. Lawyers shall use their best efforts to carry out work in a complete... My apologies for the noise. 12. Lawyers shall always behave towards their colleagues with integrity, fairness, and respect. Keep these comments in mind when studying the contents of this module and when applying your acquired knowledge in practice. Remember that principles are not limited to the professional sphere, but also apply to every aspect of the lawyer's personal life. Activity 1. How does the function of the South African judge differ from that of a continental judge? 2. Explain the assertive and sometimes aggressive behavior of counsel alluded to in the scenario at the beginning of the study unit. 3. Explain the distant behavior of the judge in the scenario at the beginning of this study unit. Feedback 1. A continental judge has an active rather than a passive role in proceedings and may therefore participate in both the pre-trial and trial stages of litigation. 2. Counsel's behavior is influenced by the principles underlying adversarial litigation. The system of litigation is based on the assumption that the truth will be discovered if both litigants give opposing versions of the same case. Legal representatives therefore take a partisan stance to promote and protect their clients' rights. 3. In Anglo-American systems of procedure, the judge is accorded a passive role limited to presiding over the trial, hearing evidence, and giving a judgment. The judge is therefore dependent on the litigants regarding the investigation of the facts, the gathering of information, the determination of the issues in dispute, and the presentation of these issues. Self-assessment: critically discuss the resolution of disputes Within both family groups and non-related family groups in African customary law, when asked to critically discuss a topic, ensure that both the strengths and the weaknesses are considered and that a conclusion regarding the topic is presented. That is the end of Learning Unit 3.